Suspended public protector advocate Busisiwe Mkhwebane will know in 2 weeks' time if the chairperson of the inquiry probing her fitness to hold office will recuse himself. Mkhwebane's legal counsel, advocate Dali Mpofu, submitted a recusal application against Qubudile Dyantyi and DA MP Kevin Mileham, accusing them of bias. Parliament's internal legal team advised that an external legal opinion ought to be sought.
Parliament's legal team says Dyantyi serves at the behest of the committee, and committee members like Mileham serve at the behest of their parties.
This is not Mr. Dyantyi's committee. It is not a one-man show where ultimately you as chair will make a recommendation to the Assembly on whether the PP has misconducted herself or is incompetent as alleged. Your role is simply to preside over the committee, but not to make decisions for the committee. Similarly, Mr. Mileham is just one member of a group of members who will ultimately collectively make the recommendation to the Assembly, and he has no more power than any other member on the committee.
Ibrahim also points out that there are no rules for the removal of a chairperson.
I'm of the view that you must personally consider the application as it's brought against you and inform this committee whether on the basis of the grounds raised in the recusal application, you're of the view that you should recuse yourself or not. Similarly, Mr. Mileham must do the same.
Members of the committee were divided on how the recusal application should be dealt with. The UDM, ATM, and Good Party wanted an external legal opinion explored.
I think the legal advice as suggested by our legal advisor is a sound route and decision.
I would like to support the general when he speaks about let us agree on the process to deal with such. Unfortunately, there is no standard procedure that deals with such matters.
I assume that external legal advice is on the second part of her two-part decision-making process where yourself and Honourable Mileham need to decide whether you need to recuse yourselves.
Chair, you do not lose anything if you recuse yourself. If anything, you will demonstrate to all of us, including the public, that the mandate of the committee is more important, regardless of who the chairperson is.
Other parties like the ANC, DA, ACDP, and Al Jama felt the recusal application must be dismissed.
So, Honourable Chairperson, I support the fact that we dismiss this application.
We have been very impressed on how you've handled the proceedings so far, and we don't agree with anything that the public inspector has said in order to have you to be recused.
I find that the application is without merit, and I do not support the application for the recusal of the chairperson.
The chairperson says he will make a ruling in 2 weeks' time.
I will table the response to the application for recusal by the public protector team. Because there are two things here that must not be conflated. There's a need to respond to each of the 12 grounds in detail, paragraph by paragraph, in a very thorough way. And if one has to respond to even to the commas and full stops that are there, that's exactly what we're going to have to do.
Dyantyi added that the inquiry will also investigate threats made against him by Mpofu last week in terms of the Powers, Privileges and Immunities Act. Ulilani Philip, SABC News, Parliament.
Right, let's talk about this matter further now with legal expert advocate Molatelo Mahapa of Mahapa Attorneys. A very good evening to you, and thank you so much for speaking to us, Advocate. We'll get to it in just a moment, but I just want to start off as a launch pad some of what was said in that excerpt by my colleague Bulelani Philip, some of the members of Parliament saying that this motion should not be entertained at all. Now, wouldn't that just double down on accusations that the committee, and not just these two members, are biased?
Indeed. I think it's very imperative that, the decisions that are made, people are aware that they would be, or they would set precedents. So there's nothing wrong in, one bringing an application, for a chairperson or somebody who was presiding on a matter to recuse themselves if they have valid reasons. And I think it's imperative that the matter should be given, more attention and be dealt with, properly.
Now, as you heard from some of the politicians interviewed in that report, some of them, said there is no precedent in terms of process on how to deal with this matter. And if this is going to be taken to outside counsel for legal opinion, what would be guiding them? And in terms of the complaints made, we heard that there are 12 of them. We'll look at some of them in just a moment, but just share your broad view on that.
I think I align myself with the fact that, there was a recommendation, for legal expertise to be required, or, an advice to be sought by the members in terms of, the legal expertise, so that they can be assisted in terms of formulating the procedure. Because even though there are no processes in place, it's imperative that, proper, procedure is followed. Even though there's no procedure, but you cannot act out of the scope, for instance, of the Constitution. Our Constitution obviously, sets out that people should be afforded, an opportunity, for instance, to be heard, for instance, to be, given an opportunity to lay what is, their side of the story in a way. So I would suggest that, and I would recommend, or even align myself with, those that are suggesting or recommending that legal expertise be brought, to the fore. For,
you say the Constitution should be used as a guide. Now, this section 194 inquiry, I'd imagine that in the past there has been something akin to it, even though it may not necessarily relate to the public protector. What are the guidelines? And I just also want to understand the reasons that are provided by Advocate Mpofu. Do they fall within the understanding of that he, Advocate Mpofu, and Mr. Dyantyi had a heated argument last week, this after Mr. Dyantyi rejected Advocate Mpofu's request for the hearings be postponed because Advocate Mkhwebane was ill. So just trying to understand what is a fair request and what is not.
Okay. Let's say, for instance, when Advocate Mkhwebane was said to have been sick or ill, obviously, she was supposed to have been afforded an opportunity, because obviously such circumstances are beyond one's control. If indeed she can come, and prove that, or provide proof that she was not well, she was not fit, she must be afforded an opportunity, to be heard, an opportunity to, to recover and come and proceed accordingly with the matter. I mean, we are in courts almost every day, but when somebody is not well, the matter gets postponed. You could have, the presiding officer not well. The matter won't proceed because they need to be afforded that opportunity to recover and come back and proceed with the matter.
So I also want to understand this, Advocate Mahapa, just in terms of, for the layman to understand. On several occasions, Advocate Mpofu accused Mr. Dyantyi of being biased against him and his client. But how do you weigh bias against exercising discretion? And just some of the comments made by Mr. Mileham. So if you say on the one hand there's a Bill of Rights, one has every expectation to have their rights accorded to them if they are not fit to attend proceedings, but there are those who would then argue that people have often used the law to unduly delay procedure and therefore manipulate it.
But you can't just make, foundings without evidence. And I think with the issues that were raised by Advocate Mpofu, it's imperative that, they should be looked into. And if there's definitely proof to that effect, or if there's merits to what Advocate Mpofu has been raising, then, they should be taken into cognizance. You can not just dismiss the allegations that are put before you without, adjudicating them, or without really looking into the authenticity or the merits thereof.
Okay.
So for instance, I know that Advocate Mpofu at some point was even raising the issue of the chairperson unlawfully and unilaterally amending the directives. If that is, one of the reasons, I believe that the necessary process should follow suit and let them look into what he's saying. If it holds merits, then, apply their minds accordingly.
All right. Thank you so much for your time.
But you can't just dismiss from a bar of soap.
All right. Unfortunately, we have run out of time. I still would have loved to engage you on the issue of how do you separate from what is seen as bias and exercising your discretion. But thanks for speaking to us, Advocate Molatelo Mahapa of Mahapa Attorneys.